Our discussion in this video is about quasi-contracts. So what can you recall about your quasi-contracts? Article 1157, sources of obligations. What are those? Law, contracts, delicts, quasi-delicts, and of course your quasi-contract. So your quasi-contract is one of your sources of obligations. So what is its definition? Those juridical relations arising from LUV. Again, ano yung LUV? That is lawful, unilateral, and voluntary acts of person based on the principle that no one shall be unjustly enriched or benefited at the expense of another. So there are two kinds of quasi-contracts, and that is the nominate and innominate. So what are your nominate quasi-contract? That is the Negotiorum Gestio and Solutio Indebiti. How about your innominate? That is those regulated by Articles 2164 to 2175 of your Civil Code. 1989 bar exam question number 8. Distinguished an implied contract from a quasi-contract. So, if we talk about implied contract, always remember that it still requires the consent of parties. Kasi kahit implied yan, it is still a contract. And what are the requisites again of your contract? That is your COC, the consent, the object, and the cause. How about if it is a quasi-contract? Does it require the consent of the parties? The answer is no, because sabi nga natin, remember your LUV, L for lawful, V for voluntary, and U is for your unilateral. So, it is not predicated on consent being a unilateral act. How about the basis? What is your basis of implied contract? That is the will of the parties. If it is a quasi-contract, it is not the will of the parties because it is a unilateral act. The basis, therefore, is the principle that no one shall be unjustly enriched or benefited at the expense of another. We'll discuss Negotiorum Gestio or your unauthorized management. So what is Negotiorum Gestio? That is, if there is this person who voluntarily takes charge of the agency or management of the business or property or of another, and that person has no power or authority coming from its owner, that is your Negotiorum Gestio. So what are its requisites? Number 1 is the gestor or your officious manager must voluntarily assume the management of the business or property of another. Take note that the proper term is gestor. So if you're going to take your bar exam, put there the term gestor and not just person. Kasi it will leave a good impression to your examiner. It means that you know what you are talking about. Second requisite is that the business must either be neglected or abandoned. Third is the agency must not be authorized by the owner either expressly or impliedly, and the assumption must be in good faith. Take note of Article 2144 kasi tinatanong yan sa bar exam. So, what is Article 24 all about? Ang sinasabi dyan, si Gestor is still obliged to continue the management or the agency of the business or property of another even if he has no authority or power coming from its owner until matapos or until the termination of the affair and its incidents. Do you differentiate Negotiorum Gestio from implied agency? First, in Negotiorum Gestio, the owner has no knowledge at all that another person is acting on his behalf. So, wala siyang kaalam-alam. Whereas in implied agency, the moment the owner becomes aware of such fact and still he does not repudiate the acts of the agent, that is considered by law as an implied agency. Second, it is essential that in Negotiorum Gestio, the business or the property should either be neglected or abandoned, and that is not the case in your implied agency. And in Negotiorum Gestio, the gestor must not have been given any authority at all by the owner to assume or to manage his business or property. Dapat wala talagang authority at all. Whereas in implied agency, you cannot say that, because in implied agency, the agent is actually authorized to assume the agency. Bakit mo nasabing actually authorized siya or meron siyang authority to assume the agency? Because in implied agency, the owner here has knowledge that another person is acting on his behalf and without his authority, and even if with such knowledge he fails to repudiate the agency, or there is this silence or inaction on the part of the owner, or the action of the owner says otherwise. So that is the difference between Negotiorum Gestio and implied agency. 1995 bar question number 11. Tingin diretso sa questions. There are two, and that is letter A. What juridical relationship between Amparo and Armando, if any, has resulted from Amparo's unilateral act of assuming the administration of Armando's apartment? So, more or less, may idea ka na, no, kung ano yung juridical relationship. And letter B is what rights and obligations, if any, does Amparo have under the circumstances? Explain. So, let's read the problem. There are two personalities here, and that is Armando and Amparo. Who is Armando? He is the owner of residential apartments. And on April 1, he left for the United States without appointing any administrator to manage his apartment, such that uncollected rentals accumulated for 3 years. Si Amparo is a niece of Armando, and she is concerned with the interest of her uncle, so she administered the property, and as a consequence, she incurred expenses in collecting the rents and even spent for necessary repairs to preserve the property. So, as far as the question number 1 is concerned, what juridical relationship? The answer is Negotiorum Gestio, because Amparo here voluntarily took charge of the agency or the management of the business or property of Armando, even if without any power or authority coming from her uncle. And again, we said we use the proper term, and the proper term is Amparo is the officious manager or the gestor. Letter B, what rights and obligations, if any, does Amparo have under the circumstances? Well, we will be discussing that later or in the next slides. What are the obligations of a gestor? Well, the answer is in Article 2145. The gestor should perform his duties with the diligence of a good father of a family. Second, the gestor should pay also the damages suffered by the owner if the same was through his fault or negligence. Another obligation of the gestor is in Article 2146. So, what happens if the gestor delegates some or all of his duties to another person? In that case, the gestor is liable for the acts of the person to whom he delegated. And the responsibility there, if there are 2 or more officious managers, is solidary. Unless, so this is your exception, unless the management was assumed to save the thing or business from imminent danger. So take note of this. 1985 bar question number 13. Tingin diretso sa tanong, are they liable for said losses? And number 2 is if they are, why, and what is the nature of their liability? So there are 4 personalities here, A, B, C, and X. So while A was abroad, the manager of his factory suddenly died, and B and C, who are A's friends, they took over the management of the factory without A's knowledge. However, since they were businessmen themselves, they had to entrust most of their duties to X, and as a result, the factory suffered losses. Are they liable for said losses? What is the answer? Yes, they are liable for the said losses. If they are, why and what is the nature of their liability? So, kababasa pa lang natin, kakasabi pa lang natin, the answer is based on Article 2146. If the gestor will delegate the duties to another person, he or the gestor is still liable for the acts of that person. And the liability, if there are two or more officious managers or gestors, is solidary. And that is also the answer of the UP Law Center. So what else are the obligations of a gestor? Your answer is in Article 2147 and in Article 2148. So the officious manager or your gestor is liable for any fortuitous event if he undertakes risky operations which the owner was not accustomed. Number 2, if he preferred his own interest. Number 3, is if he fails to return the property or the business after demand by the owner, and if he assumed the management in bad faith. Take note of this because according to what we have discussed, one of the requisites of your Negotiorum Gestio is that the assumption must be in good faith. So here, the assumption was made in bad faith. Therefore, if there is any fortuitous event, the gestor is liable. The gestor is also liable for fortuitous event if he is manifestly unfit to carry on the management. And last is if by his intervention, he prevented a more competent person from taking up the management. Please take note, however, that when it comes to the management, there is this exception. If the management was assumed by the gestor to save the property or business from imminent danger, then your officious manager or gestor is no longer liable for fortuitous event. Take note of this Article 2148 na exception because you saw this also when we read that Article 2146. Let us recall again what is your Article 2146. Sabi doon, if the gestor delegates some or all of his duties to another person, then he is liable still for the acts of that another person. And the liability there, the nature is solidary if there are two or more officious managers. But there is that exception, and that exception is the same here in Article 2148. If the management was assumed to save the property or business from imminent danger, then the gestor is not liable. There is this 1993 bar exam question, number 13, diretso tingin sa tanong, is B liable to A for damages under the foregoing circumstances? So, let's read the problem. There are three personalities, and that is A, the owner, B, the gestor or the officious manager, and C, another person. So, A disappeared from his residence. B, who is his immediate neighbor, noticed the mysterious disappearance of A. So what he did is he closed the doors and the windows of the houses of A to prevent from magnanakaws. And years passed without B hearing from A. B continued to take care of the house of A, even causing minor repairs. In 1976, C approached B and proposed that they build stores at the ground floor and convert the second floor into a pension house. So B agreed to the proposal of C. While the construction was going on, a fire occurred at a nearby house. So the houses at the entire block, including the house of A, were burned. In 1986, A returned from the US, and upon learning of what happened to his house, A sued B for damages. B said that he merely took charge of his house under the principle of Negotiorum Gestio. He also said that the burning of the house is a fortuitous event. Is B therefore liable to A for the damages suffered under the foregoing circumstances? So what is your answer? Recall Article 2145 and Article 2147 because these are your answers to this question. Ano ba yung sinasabi ni Article 2145? Article 2145 says that the gestor is liable to pay for the damages suffered by the owner if the same was through his own fault or negligence. So in this case, ang fire ba is through the fault or the negligence of B? Diba hindi? So, that is your answer. How about the fire? Is fire a fortuitous event? Yes, it is a fortuitous event. But ano ang sinasabi ni Article 2147? Ang sinasabi ni Article 2147, gestor is liable for fortuitous event if he is guilty of any of the following circumstances mentioned therein. And what are those instances or circumstances mentioned therein? Number one is if the gestor assumed the management in bad faith, or the gestor failed to return the property or the business after demand by the owner, or if he preferred his own interest, or if B undertakes risky operations. So in that case, if B is guilty of any of these circumstances or instances, therefore he is liable for damages. Or if he is not guilty, then he is not liable for damages. So this is how you attack this problem. So what else are the obligations of a gestor? Ano ang sinasabi? If the gestor enters into a contract with another person or with a third person, sabi ng Article 2152, the officious manager is personally liable for contracts entered into with a third person. And take note that there is no right of action between the owner and said third person. But is this rule absolute? Again, the answer is no. Because if the owner has expressly or tacitly ratified the management, therefore your officious manager is no longer liable. What else? If the contract refers to things pertaining to the owner of the business, then again your officious manager is not personally liable. We are done discussing the obligations of the gestor. How about your owner? Meron din ba siyang obligations? There is, and that is your Article 2150. So the owner of the property or the business is liable for obligations incurred by the gestor in his interest. Also, the owner of the property or the business has the obligation to reimburse the officious manager for the necessary expense, the useful expense, as well as the damages which the gestor may have suffered in the performance of his duties. How about if the owner did not derive any benefit at all? So, ano ang mangyayari? Well, the owner has still this obligation if the management was for the purpose of the prevention of an imminent and manifest loss. Take note of Article 2149. What is the effect if the owner of the business ratifies the management of the gestor? There is an express agency. Express agency. So let me end this video through this 1992 bar exam question number 13. X here, who is the owner of the fish pond, he fled to Manila. And Y, who is in the business of managing fish ponds on a commission basis, he took possession of the property, he harvested the fish, and he sold the entire harvest to Z. Y thereafter borrowed money from another person, and that is W, and he used the money to buy new supplies to prepare the fish fund for the next crop. So what is the juridical relation between X and Y? And your answer is Negotiorum Gestio. Y is the gestor or the officious manager, and X is the owner. Letter B. What are the obligations of Y to X as regards the contract with say? So, Y here, or the officious manager, must render an account of his operations and deliver to the owner the price he received for the sale of the harvested fish. Letter C. What are the obligations of the owner as regards Y's contract with W? So, ano ang sinabi natin? In Article 2150, sabi doon, the obligation of the owner of the property or the business is liable for the obligations incurred by the gestor in his interest. Therefore, X must pay the loan obtained by Y. Letter D is, what is the effect if X expressly ratifies the management of Y? Ano ang sinabi natin? There is an express agency. So this is the end of the video. Thank you very much for watching, and the next topic will be solutio indebiti.